Hi, everyone. Welcome in. I'm seeing people come in already. My name's Kenya. I'm from the San Diego Law Library. And with me today, we have Leslie Adams from the San Diego Volunteer Lawyer Program. Before we get started, I'm just going to go over some housekeeping rules. First of all, we are not offering continuing legal education credit for this webinar, if that is what you're looking for. Unfortunately, this is not it. This is going to be an interactive presentation, so feel free to use the Q&A function at the bottom to ask our presenter questions. You can either ask them anonymously or use your own name. We do ask that you keep your questions general rather than use the specifics of your situation. And one last thing, there is going to be a link to a short survey at the end of the presentation, and we'd really appreciate some feedback, so if you guys could fill it in. And with that, I'll pass it on to our presenter.
Good morning, everybody. My name is Leslie Adams. I'm a staff attorney at San Diego Volunteer Lawyer Program. It is a nonprofit in San Diego. Today, I will be talking about the California Tenant Protection Act of 2019. The California Tenant Protection Act was signed into law in September 2019, but became effective January 1st, 2020. I know that's going back a ways. Let me go ahead and share my screen and we'll go ahead and get started. Here we go. I hope everybody can see that. If you can't, please mention that in the chat. So as I said, the California Tenant Protection Act, it's a California law. It applies to all tenants unless, we'll get to the unless later. It became law in September of 2019 and became effective January 1st, 2020. Recently, there have been some amendments to the California Tenant Protection Act, and those became effective on April 1st. Some general information here. This is a general legal presentation and does not constitute legal advice. At no time will an attorney-client relationship be created. Doesn't cover every single landlord-tenant relationship. And as Kenya said, please keep your questions general as opposed to what's happening to you right now. This will not cover the City of San Diego or the City of Chula Vista tenant protection ordinances. However, we will give them a slide or two later on in the presentation. Questions will be accepted at any time, but if it can wait, I ask that you wait until the end so as not to interrupt the presentation, and slides will be distributed after the training. As I said, San Diego Volunteer Lawyer Program is a nonprofit in San Diego. I'm going to move my little window up there. Stand by. There we go. We provide services to disadvantaged and low-income individuals in San Diego County. Within SDVLP, there's a tenants' rights program. I run the tenants' rights program. Here is a quote from Matthew Desmond, the author of best-selling book, Evicted: Poverty and Profit in the American City. Basically, he believes that housing, affordable housing, is a right for everybody in this country. Let's get started. So we're going to go over the eviction overview because sometimes people misunderstand that eviction is a process. So it basically starts with an eviction notice. That's what we're going to be talking about today, how the Tenant Protection Act applies to eviction notices in California, specifically San Diego County. But you should know, if you are a tenant, that eviction is a process. When a tenant receives a 30, 60, or 90-day termination of tenancy or eviction notice, it doesn't mean that they have to leave tomorrow. The eviction notice has a duration. At the expiration of that duration, if the tenant and landlord have not come to some alternative agreement, then the landlord has a right to file an unlawful detainer, also known as an eviction lawsuit or a UD. In response to the UD, a tenant files an answer. The answer has to be filed within 5 court days and filed at the court. In the answer, the tenant is able to provide what we call affirmative defenses, basically something defending why they should not be evicted. After the tenant files an answer, the landlord requests a trial date. The court sets a trial date, and then the landlord and tenant either show up in court, or you have options of going online to try your case or defend your case. So within the eviction overview was the eviction notice. This is the eviction notice overview. So eviction notices must strictly adhere to California law, must be in writing, and if it is defective, meaning it doesn't adhere to California law, it may provide an affirmative defense. As I was saying, tenants have the option to file an answer in response to a UD, and inside that answer is are different affirmative defenses. Namely, what we're talking about today is defective eviction notices. Here are the types of notices. So we're not going over the 3-day notices today, but you should know as a landlord or a tenant that there are a variety of different durations for eviction notices. 3-day notice to pay or quit means a tenant hasn't paid their rent on time, and the landlord is requesting or demanding that the tenant pay the rent or get out. The same goes for the 3-day notice to cure or quit. Cure is another word for fix what's wrong. And in a 3-day notice to cure or quit, a landlord tells the tenant what is wrong and why the tenant may be evicted, and the tenant has an obligation to fix that problem within a certain amount of time, 3 court days, or get out. The 3-day notice to quit is a little bit more strict. This is for extreme material lease violations and is not favored by the court. Moving on to what we're going to be focusing on today are the 30, the 60, or the 90-day notice to quit. This is a termination of the tenancy. How do you calculate the expiration of a notice? First of all, there are court days and there are calendar days. So if it's a 3-day notice to pay or quit, pay the rent or get out, fix the problem or get out, those are court days. Court days means no holidays and no weekends are counted. So if you received a 3-day notice to pay or quit on a Friday and Monday was a holiday, Friday is day 0 and Tuesday is day 1. 1, 2, 3, Tuesday, Wednesday, Thursday. That means by Thursday at 5, you would have to take care of whatever it is you're supposed to fix. Calendar days refers to the 30, 60, or 90. Those include weekends and holidays, but it's day 0 when you receive the notice and day 1 the day after the service of the notice. The service of the notice is another aspect of the eviction notice. If it is defective, it could be used as an affirmative defense. Here are ways a notice can be served. Personal service is basically what we all know, being personally handed the notice. Substitute service means there's another adult in the household. The tenant on the lease might not be there, but another adult in the household could be served the eviction notice. But in this case, and it is highlighted for a reason, It's not a gray area, it is black and white. If it is substitute service, it must be mailed first-class mail to the tenant's address. The same goes for the nail and mail method. It must be posted conspicuously on the property and mailed by way of first-class mail. So questions come up like, well, what if the landlord puts it in the mailbox without postage? First of all, that's against federal law. So I would argue that is not proper service. But if that's the only thing wrong with the notice, like the notice is valid, but the service is invalid, tenants must understand that a court might find actual notice has been effective, and they will not necessarily dismiss your case for defective service if the notice was placed in the mailbox and not actually mailed by way of first-class mail. Identifying the types of tenancies is very important when we come to looking at the law and its application. Here are some examples of types of housing units. Whether you're a landlord or a tenant, you may see your housing unit here. The type of lease is also important. Do we have a fixed term lease or a periodic tenancy? So fixed term lease is like a 1-year lease from January 1st to December 31st. Some of you, if you're tenants, you may be in a fixed term lease. You cannot be evicted unless you are violating the lease because you're in a fixed term lease. So basically from January 1st to December 31st, a tenant is protected in that fixed term lease, the same terms and conditions, the same rent, the same, let's say, pet fee, whether the tenant is paying utilities or not. If the fixed term lease says utilities are paid by the landlord, then for that period of time, the utilities are paid by the landlord. Periodic tenancies are what you find after a fixed term lease typically, or sometimes a lease starts off as a month to month. So if a tenant has been in a fixed term lease that converts to month as of January 1st the next year, they begin a periodic tenancy. Sometimes a lease is written. This is a month-to-month lease. Periodic tenancies can be terminated by either the landlord or the tenant with at least 30 days notice. For California law in general, length of tenancy is important. So if the tenant has been in the rental unit, residential rental unit, we are talking only residential here. So if there are commercial tenants or landlords on here, I apologize, but none of this applies to you. If a tenant has been in the rental unit for less than a year, it is required to serve at least 30-day notice. If the tenant has been in the unit more than 1 year, it is required a 60-day notice. Now that's just California law. Maybe you think, well, can a landlord actually serve a 60-day notice on a tenant who has been in the unit less than a year? Of course. But to a tenant that's been in a unit more than 1 year, can the landlord serve a 30-day notice? No, not generally. As you see here, the exception is Section 8 voucher tenancies. They require a 90-day notice, and that's after the initial contract term has expired. So typically, Section 8 tenancy will start with a year. I think I've seen one with 6 months. During that period of time, unless there is a breach, a material breach of the contract or material breach of the lease, the tenant cannot be evicted. Following the end of that contract period, the tenant must receive at least a 90-day termination of tenancy notice. Can the landlord serve more than a 90-day? Yes. 120-day, I've seen it. It's possible. Here is something that's exclusively California law, does not have anything to do with the Tenant Protection Act. All 30, 60, 90-day notices must have an abandoned personal property clause in it. The language is specific to the law, to the California Civil Code. The code is there if you wanted to look it up. Omission of the abandoned property statement in a notice may be an affirmative defense to an unlawful detainer or eviction. So now we're going to get into the Tenant Protection Act. The Tenant Protection Act requires in certain tenancies where the law is applicable that the landlord provide a just cause. You may have heard this term and thought, what is that? Well, it's just a reason for terminating the tenancy. There are two types of just cause, at fault and no fault. At fault sounds like exactly what it is. The tenant has done something to trigger the landlord wanting to terminate the tenancy. No fault is the opposite. The tenant hasn't done anything, but the landlord desires to terminate the tenancy for a reason. So just cause is just a reason for terminating the tenancy. So you'll hear this a lot. We are addressing the Chula Vista and the San Diego residential tenant protection ordinances here. When is just cause required? It is required where any of these ordinances or laws apply to the tenancy, and we'll get to that in a second. In the California Tenant Protection Act, it applies to tenancies that are greater than 1 year. Chula Vista and San Diego apply as of day one of the tenancy. So this should be good news for tenants. So now the California Tenant Protection Act of 2019 applicability to tenants. So we know the tenant has to be there 1 year, but what if you have more than one tenant? So if the single tenant has been there more than 1 year, or all the tenants have been there more than 1 year, applicable. Or you have several tenants and at least one tenant has been in the unit more than 2 years, applicable. But even if all this is right, if the unit itself is not subject to the Tenant Protection Act, then it's not applicable. So we'll get to that. Here are the exemptions. This means these units, if you're a tenant and you see on this list a situation that you live in, it is most likely not subject to the California Tenant Protection Act. So you see single-family homes or condominiums with no corporate ownership and notice of exemption is highlighted. And there's a reason for that. We'll address that in just a moment. Let's see. So for the most part, I think it's self-explanatory. Owner-occupied single-family homes. So this means when tenant lives in the home and the owner considers the home their primary residence. Then you look down a few and you see tenant who shares bathroom or kitchen with an owner at the owner's primary residence. This could be slightly different. This is a tenant who's considered a solo lodger. So someone owns a condo and rents out a room, and the owner and the tenant who's renting out a room live in the same space. So let's explore the single-family home condo situation. Single-family home or condo, they are what's called separately alienable. So think about condo, it's kind of like an apartment in a building, but it can be sold separately, whereas apartments can't be. The apartment in an apartment building, that building is one unit, and that can be sold. but the actual individual apartment can't be sold. Condos, on the other hand, are sometimes units in a building with many other condos, and they are sold separately. Each condo is owned by someone, well, could be owned by a bunch of different people, or for instance, an LLC could own several condos, but they're all rented out. So if a tenant lives in a condo or a single family home, the Tenant Protection Act might not apply. There can be no corporate ownership, and the landlord has to serve the tenant with a notice of exemption. Here is language directly from the code. The code is the law, California Civil Code, California law, all used interchangeably. So now look down here at statement must be provided in the lease or the rental agreement if it's entered into after July 1, 2020. So if you're sitting out there and you're thinking, wait a minute, my lease started after July 1st, 2020, you might want to have a look at it. Is the notice of exemption in your lease? Or maybe your tenancy is subject to the Tenant Protection Act. It all depends. It's a very fact-specific analysis. So we're going to explore at fault just cause right now. Here are a list of reasons, kind of conundrums that tenants get themselves into and end up having their tenancy terminated. So if a tenant receives an eviction notice and it has one of these reasons in it, it is an at-fault just cause. It means the tenant did something that triggered the termination of the tenancy. Here are the only 4 no-fault just cause reasons a landlord may use in order to terminate a tenancy. Move-in by owner is very specific. It doesn't have to be the actual owner, but the owner or the owner's spouse, domestic partner, then it goes down, children, grandchildren, and then it goes up, parents, grandparents. That's it. So this is new language. This is the newly effective as of April 1st language. Before, the Tenant Protection Act didn't define move-in by owner, and you'll see there are other protections. So this move-in by owner becomes the intended occupant. We're going to talk about the intended occupant later. Another reason, withdrawal of residential real property from the rental market. Typically, the landlord is required to withdraw all of the residential rental or real property from the rental market. Compliance with a government order, court order, or local ordinance that requires vacancy. Think along lines of habitability problem. Let's say there's plumbing issues, there's rodent infestation, and someone called code enforcement. Code enforcement came, looked at the rental property and shut it down because it is not habitable. It's not fit for a human being. So sometimes landlords have to comply with the government order or court order. They have to shut the place down. And that would be a no-fault just cause reason to terminate a tenancy. And finally, intent to demolish or substantially remodel the residential real property. In the past, this has been kind of a loosey-goosey, if you will, reason and used more often than not by landlords. But their intent was not actually to demolish or necessarily substantially remodel. So move-in by owner and intent to demolish or substantially remodel are both stronger, no fault just cause reasons, and we're going to talk about that. Here is the no fault just cause owner move-in. All of this applies. I'm not going to read every bullet point, but I'll go through it so that you have a really good idea. Keep in mind the slides will be distributed following the presentation. So the owner move-in termination has to be a provision in the lease that allows termination of tenancy by owner move-in, or the tenant has had to agree in writing. So now I know if you're a tenant, you're probably thinking, wait a minute, I need to look at my lease. Yes, that would be a good idea. The intended occupant, we went over that, who it can be. So what you don't see in here, for instance, are sister, brother, niece, uncle, aunt, nephew. But let's say it's a child, an adopted child. That child is allowed to be an intended occupant. So a tenant has received a notice to terminate their tenancy, and the no fault just cause used is owner move-in. So after that period of notice, the intended occupant is required to move in within 90 days of the tenant vacating and must use the unit as their primary residence for 12 continuous months. So these are all stronger aspects of this no fault just cause reason. And these are the newly effective reasons, which is why we're having this presentation today. In the past, there was no requirement that an intended occupant move in. There was no requirement that they remained. And in some cases, landlords were able to use a quote unquote owner move in, no fault just cause, and then actually no owner or relation of the owner moved in, and the owner increased the rent and re-rented the place with maybe a new paint job. So if the intended occupant already resides on the property in a rental unit, this owner move-in doesn't apply. The landlord cannot use it. If a vacancy already exists at the property, the landlord cannot use owner move-in. The landlord has to provide the name of the intended occupant and their relationship to the owner. And additionally, the tenant may request proof that the intended occupant is related to the owner. Upon request, the owner must provide proof upon request. I guess I really wanted to emphasize upon request. Okay, so you may be thinking, if you're a tenant, or maybe if you're a landlord, you're like, well, what if the intended occupant does not comply with the law? If they fail to occupy the rental unit within 90 days, or fails to occupy the unit for 12 months, the owner has to offer the unit back to the original tenant, same rent, same lease terms, and reimburse the tenant for reasonable moving expenses incurred over and above the relocation assistance. So that's a pretty strong protection for tenants. As housing advocates in California, we believe when we see an owner move in, no fault, just cause, because of these remedies, it's more likely than not the owner is actually got an intended occupant in mind and is moving them into the unit. So you'll see there in small print, there is an exception. If the intended occupant dies while occupying the rental unit, the landlord is not on the hook for offering the unit back to the original tenant. We're moving on to the other no fault just cause, which is newly effective, the intent to demolish or substantially remodel. Now, in the past, there were not so many requirements for an owner to use intent to demolish or substantially remodel. So what the California legislature did is they increased the protections by making this a little bit more difficult for landlords. In the end, what the legislature is trying to do is to curb, prevent further homelessness, or curb the homelessness problem that we're currently dealing with in all of California. So here's a definition of substantial remodel. Basically, it is work that will require a permit. However, the abatement of hazardous materials doesn't always require a permit. But these two reasons right here, substantial modification of structural, electrical, plumbing, or mechanical systems, those are substantial remodel. Abatement of hazardous materials. Think lead-based paint, not pain, mold or asbestos. If a landlord is coming in to change the carpet, replace the flooring, change the countertops, paint the inside, paint the outside, do new windows or new window dressings. This is not considered substantial remodel and is not a reason to force a tenant to vacate. So you'll see in the bottom, the no fault just cause may be used only if the work described cannot reasonably be accomplished in a safe manner with the tenant living in the rental unit. So for instance, repainting, that can be completed with the tenant in the unit. Other cosmetic improvements can be accomplished with the tenant still in the unit and does not require the tenant to vacate for 30 days. Here are additional aspects of a landlord's use of intent to demolish or substantially remodel. So the landlord has to include a statement informing the tenant of the owner's intent to demolish or substantially remodel, and another statement, which is on the next slide. It's a full statement right out of the law, right out of the California Civil Code, to the tenant about what happens when the substantial remodel or demolition is not commenced or completed. So keep that in mind because we're going to see that on the next slide. The landlord also has to provide a description of the substantial remodel to be completed, the duration, and if the property is being demolished, the expected date by which it will be demolished. Together with, we talked about this earlier, copy of the permits required or a copy of the signed contract. For instance, where a hazmat abatement does not require a permit necessarily, it does require a signed contract with a contractor who does that sort of work. Also, and not finally, but also, a landlord must provide a notification to the tenant about reoccupying the rental unit and the tenant informing the landlord of their interest. And so that comes after the substantial remodel, obviously not the demolition. After the substantial remodel, if a tenant is interested in reoccupying the unit, the landlord has to notify the tenant. But the landlord is not required to provide the same lease, the same rent, or the same rental terms. Here is the required statement that the landlord must provide in the notice to the tenant when using intent to demolish or substantially remodel. And basically, this tells the tenant that if the work is not done like we said it was going to be done, then you get to come back. Same terms as the most recent rental agreement at the same rental rate as when the tenant vacated. The tenant has some obligations here too. The tenant has to notify the owner within 30 days that they are interested in re-renting the unit. and then they must reoccupy the unit within 30 days. So the no fault just cause requirements, the landlord is required to provide in the no fault eviction notice a valid just cause reason. See previous slides, that's what we just talked about, at fault or no fault. And we specifically went over the two no fault reasons that are newly effective as of April 1st. And relocation assistance in the amount of 1 month's rent. So a landlord we'll go back kind of an overview. So the landlord, the tenancy is subject to the law. The landlord has to provide an eviction notice at fault or no fault. If it is no fault and the landlord uses a valid no fault reason, they also are required to provide relocation assistance in the amount of 1 month's rent. So this is only a no fault, not an at fault. Can the landlord provide more than 1 month's rent? Yes. They are required to provide at least 1 month's rent. The 1 month's rent can either be a waiver of the last month or a direct payment made to the tenant in the amount of 1 month's rent within 15 days of the notice, the eviction notice. So the eviction notice or the notice of termination of tenancy is the same thing. It's 30 or 60 days as soon as the notice is served on the tenant. If the landlord intends to make a direct payment, they would have to do so within 15 days of that, the service of that notice. I hope that made sense. In conclusion, concluding, oh, pretty good. The California Tenant Protection Act became law in September 2019, effective January 1st, 2020, and has recently been amended with stronger protections for tenants and more obligations for the landlords as of April 1st, 2024. Stronger protections, these are efforts to prevent arbitrary evictions, which sometimes lead to homelessness. And this California Tenant Protection Act is the floor. So this is the standard. If a city, for instance, city of San Diego, city of Chula Vista, maybe city of Los Angeles, if a city is going to provide protections in its own ordinance, California Tenant Protection Act is the floor. The ordinance must meet at least the California Tenant Protection Act protections, and they can go further to make even stronger protections. So summary of potential issues as a tenant or a landlord you may face. Defective service of notice. Understand though that if the service is defective, but that's the only thing wrong with the notice. Otherwise, the landlord got the notice correct. That might not be, the defective service is not necessarily a strong argument, and it might not be the most effective argument for getting a UD dismissal, a dismissal of an eviction lawsuit. Defective notice, if the notice does not comply with the California Tenant Protection Act, and there are a lot of things to do for a landlord, a lot of obligations. The landlords have to get it right. And the reason the protections are so strong is because we're talking about someone's home. And if you think about it, whether you're a tenant or a landlord, to be told today, well, in 30 days, you have to be out. In 30 days, you have to find a new place to live. In 30 days, all of this has to go away. This is why the landlords have to strictly adhere to all of the requirements in the California law with regard to eviction notices. The just cause could be unlawful, false, or did not occur. So in some instances, a landlord may use an at-fault just cause. And for instance, the tenant smokes and the unit is non-smoking and the property is non-smoking. Well, has the tenant seen other people smoke? Does the property manager smoke? the tenant in that case might think, well, wait a minute, this isn't directed at me as a smoker. This is directed at me as a tenant they want to get rid of. Yes, exactly. And so that is what we would call a pretextual reason. The landlord is giving what appears to the outside on paper a valid reason, but it's not. It's pretextual or a lie. If the just cause is unlawful, or it's, let's put it this way, it says renovate unit. Well, if you look at the law is pretty clear on the 4 reasons. So if you are a landlord and you are watching this presentation, I beg of you to look at the law and get it right and use one of only the 4 reasons. Don't make up reasons. If a landlord makes up a reason, it's probably not lawful and it renders the notice defective. And for that reason, if the landlord is able to file a UD or an eviction lawsuit, the tenant will have a really good affirmative defense. And at that point, the landlord will have to start all over. Pretextual, we talked about that. Sometimes it's discriminatory or retaliatory. For instance, if you are a tenant and you have complained about rodent infestation or a broken front door lock, something that the landlord should be fixing and they refuse to fix, and instead of fixing it, they serve an eviction notice. That eviction notice is retaliatory, most likely retaliatory, provided there aren't any other intervening factors. And that provides a really good affirmative defense to a UD or an eviction lawsuit. Other things we see are unlawful rent increase. So for instance, the landlord is evicting the tenant because they want to slap a coat of paint on the unit and double the rent. That's unlawful. And sometimes landlords engage in self-help. Most landlords, I would like to say, know better. They can't change the lock. They can't throw your stuff out on the street or on the front lawn. They can't turn off the utilities. They can't turn off the heat. They can't turn off the electricity. If a landlord is engaging in self-help, specifically if they lock you out of your unit and you're a tenant, provided you have proof on you that you reside in this particular unit, you call the non-emergency police, and the police should show up. You prove that you live there, and the landlord has to open up and let you back into the unit. Here are some resources. This is kind of an overview of resources. San Diego Volunteer Lawyer Program is where I'm coming from today. Legal Aid Society of San Diego is an awesome resource. You can go to their website. They have documents and information you can download, fact sheets you can download, which are really helpful and are geared towards a layperson. Their phone number is there. They also have an eviction clinic in the Hall of Justice downtown. Tenants Together is a great website to visit. They have a toolkit whereby they have letters, sample letters that you can use, and you just, as a tenant, you input your information into a Microsoft Word document that basically provides a letter, given whatever your reason is or whatever your issue is. And you just plug in your information and you have a letter ready to send to the landlord. California Western has a community law project. They help out with, I believe, all aspects of tenancies, but you might want to call that number and find out if you have a specific question. The San Diego County Bar, as well as the North County Bar Association, they are both bar associations in San Diego County. Both have lawyer referral services. These are lawyers that you get a free 30 to 60-minute consult with, and sometimes they agree to take your case. It's not usually on a pro bono basis, though. You should know that. It might be at a reduced hourly rate or a reduced fee. Self-help through the Superior Court. If you look at the Superior Court website and look for information about being a landlord or a tenant, lots of resources there. Keep in mind, these slides will be distributed. However, if you want to take a picture of the slide, go for it. So for SDVLP, San Diego Volunteer Lawyer Program, we have two different clinics, two types of clinics. So one is the remote eviction notice clinic. This is a clinic that I run every Thursday morning at 9:30 a.m., whereby we pair a tenant who's in receipt of an eviction notice, 30, 60, or 90-day eviction notice, with a volunteer attorney. And that volunteer attorney goes through a series of questions regarding the circumstances surrounding the eviction notice. And the purpose of the clinic is to determine if the notice is valid or not and advise the tenant accordingly. So every tenant who comes to the eviction notice clinic is advised what to do next based on whether the eviction notice that they have been served is valid or not. It would be great if you are a tenant or you know someone who is a tenant and who has received an eviction notice. Please, please, please apply to our program so that we can get you into an eviction notice sooner rather than later. Sometimes we have clients who I'm not sure, I know it's a very stressful situation when you receive a 30 or a 60-day notice, but you should not wait until the end of that period to ask for help. As soon as a tenant receives an eviction notice, unless they have a plan to move out, they should apply for legal help. It's free. And we would love to host you at the eviction notice clinic, provided you are eligible for our services. We also have an unlawful detainer clinic. Now, this unlawful detainer clinic is located in the North County Courthouse. If you are currently living somewhere far away from North County Courthouse, let me put this little bug in your ear. If you want to go to the unlawful detainer clinic, parking is free. I don't know, maybe that changes your mind. Anyway, at the unlawful detainer clinic, it is open to tenants or landlords. You will not receive advice from an attorney, but there is a very good attorney, well-versed in landlord-tenant law, who staffs that clinic, and she will offer information that will get you going towards what you need to do. She's there Tuesday, Wednesday, and Thursday from 8:30 to 1:30. I know that is a very small window. If you can't make that and you are a tenant, apply for the eviction notice clinic. I wanted to show you how to apply. Let me make sure I don't have anything else. Nope, I don't. So I wanted to show you how to apply. Let's see. I wonder if it lets me share a different screen. No. So I'm going to stop the screen sharing, and then I'm going to show you how to apply on our website. I have to share again, but we're going to go a different place. I think, not there. Let's try this one. Okay. That was not it. Oh, let's see here. I don't think that is it. I am looking for, let's see here. Stand by. I see questions are coming in. Just give me one moment, please. Okay. There we go. That's what I'm looking for. This going from one share to another share, sometimes not so easy. There we go. Okie dokie. So here is the SDVLP. If you go sdvlp.org, this is our website right here. Oh, get help. Whoa. Now, this is not a slide in the presentation, so I'm going to leave this up for a second. Please, if you have a camera and you think you might need free legal assistance, take a snapshot of this screen. All you have to do on your phone, your tablet, your computer, or your neighbor's computer, sdvlp.org, get help. Cursor is just on get help right now. These are all of the different programs we have at SDVLP. Here's mine right here: landlord-tenant, housing law, landlord-tenant disputes, eviction. I'm going to click on eviction and show you what the screen's going to look like if you come to our website and try to apply for services. Housing law. Okay, you see me on the right-hand side. I hope that's your right. Scrolling down. Tenants rights program, other legal services. You'll see right there, we've got security deposits, unlawful rent increases, reasonable accommodations. Ooh, here we go. If I had a highlighter, I would use it. Tenants rights program, remote eviction notice legal clinic, right there. Et voila. You apply for the remote legal clinic right there by clicking on that, filling in some information. You will receive, usually within a couple of hours, but I'll say within 24 hours, you will receive an email or a call from my assistant, Carla, who will be attempting to gather information to ensure that you are eligible for our services. So again, this is sdvlp.org. Go under Get Help. Check out all the options. If you are a tenant, here's where you're going to start, right here. Here's the information about the unlawful detainer clinic. I'm sorry, I went too far. There we go. The unlawful detainer clinic at the Vista Courthouse. Again, free parking. If you want to come to North County. Okay. So let's go ahead and open the floor for questions. Kenya, are you there?
Yes, I am.
All right. Thank you very much for everybody's attendance. Really appreciate it. And we'll go ahead and answer some questions now.
All right, so the first question from one of our attendees is, if a tenant receives a 60-day termination notice in a non-owner occupied single-family home and hasn't received an exemption disclosure from the TPA, do just cause protections apply?
Okay, so we're talking about a single-family home, which is separately alienable. And in that case, in order for the single-family home to be exempt from the law, the ownership can't be corporate and the landlord has to provide a notice of exemption. If the notice of exemption is not provided, then I would argue, yes, that just cause and relocation assistance apply.
Okay, our second question is, how does move-in by owner in no-fault evictions work if an apartment is owned by a trust rather than a person?
Okay, let's see. Is it the relatives of the owner of the trust or the relatives of the benefit? Okay, Mr. or Mrs. Anonymous. That is a factual analysis that can be done, just not within this presentation. I'm sorry. The answer, and I don't know if you know any lawyer friends, but our answer to questions like this are, it depends. And it really does. It's there is information about that in the law. And I would encourage you to do a Google search And if you can't find the information, you might want to go to the unlawful detainer clinic in the North County Courthouse. Or if you are eligible for our services, please apply to the eviction notice clinic.
All right, we have another question from our attendees. If the TPA doesn't apply because it is a single family home, what notice is required for ending a month-to-month tenancy for tenants living in the rental for greater than 1 year?
Okay, good question. You guys are really like diving in deep to the nuances of this law. So the single family home, again, no corporate ownership, and there's a notice of exemption. And so now we're saying just cause reasons and relocation assistance doesn't apply because the landlord got it right. The owner of the single family home got it right. The tenants have been there more than 1 year. It's 60 days. It's 1946.1 California Civil Code. You can look that up. It's also in the slides. If a tenant is in a unit less than 1 year, minimum 30 days, more than 1 year, minimum 60 days. Could it be 120 days? Sure. But minimum is 60 days for any tenancy more than 1 year.
All right. Another anonymous attendee asked, the law was intended to keep rents reasonable, but since it went into effect, landlords have been allowed to and have been raising the rent 10% every year. How does this help tenants?
Okay, so when you say the law, that's vague and ambiguous, if you will. The California Tenant Protection Act was enacted originally for the purpose of preventing arbitrary evictions. So there was no more willy-nilly, in 30 days, you got to get out. There was no more eviction notices allowed in something other than in a proper writing. There was no more willy-nilly reasons for evicting tenants. So the law you may be referring to is 1947.12, which is the quote unquote rent cap for California. The rent cap, we did not cover it today. That is a different, actually, it's might be really good presentation material, unlawful rent increases and the California quote unquote rent cap. We did not cover it today. The rent cap, the purpose of the rent cap would be to prevent excessive rent increases, indeed. However, the rent cap has some nuances that I can't explain in this period of time, but I think maybe we'll put that on the calendar for a future presentation.
All right, and we have one more question. If a tenant has moved out of a property due to mold, is a landlord required to provide comparable lodging until the mold is cleared?
Yes and no. It depends. It depends on whether there's a provision for that in the lease. It depends on if the unit was shut down by a government agency. And yeah, that's also a factual analysis that's not just black and white.
And then we got one last question. If a notice of exemption is not in the lease, can a landlord later add it? And what would be proper notice for this?
The notice of exemption. So you'll see the slide when you receive it. The notice of exemption, according to the law, has to be provided in the lease if the lease was signed or entered into after July 1st, 2020. So keep in mind, the law came into effect, became effective January 1st, 2020. So at that point, all landlords are kind of on the hook to understand what the law is if they're going to be landlords. So any lease entered into after July 1st, 2020 has to have the notice of exemption in it. A lease entered into prior to July 1st, 2020. So the landlords were given a break January 1st through July 1st or June 30th. Or anytime before then. Just spoke to a tenant the other day who had a lease from 2013, and it's just been rolling month to month since it expired in 2014. That landlord, if that unit was exempt, potentially exempt from the California Tenant Protection Act, that landlord should provide a notice of exemption as an addendum to the lease, or create a new lease that includes the notice of exemption. But the notice of exemption is the language that's in the law. And the notice of exemption is right there for landlords to copy and paste right out of the California Civil Code. Hope that answered the question. Do we have another question? Oops.
Yes, we do. I
Oh,
think it's a
okay.
follow-up question to
Yeah.
that one.
Okay.
So what happens if a lease did not have the exemption, but there's a new owner and they want to add it?
So typically, I don't know what exactly, I have to refrain from a personal situation here and just go general. Typically, if a unit has been sold, so we're talking about a condo or a house, a unit has been sold and a new owner comes on. A new owner typically is in receipt of tenant estoppel certificates. That's a certificate signed and dated by each tenant and landlord and the original landlord about the terms of the tenancy. That landlord, that new landlord or that new owner has a lot to do. And one of those things is, hey, when you pay your rent, you need to pay me. Here are my details. Hey, there's been a change of ownership. And while doing that, it would probably be a good idea for the owner to strike up some new leases with the tenant or their tenants. And in the lease, it's a lease signed in to after July 1st, 2020. Therefore, the notice of exemption goes in the lease.
So
Good
that was
questions.
our last question.
Good question. Great questions. I hope everybody enjoyed this, and please, please, please respond to the library's survey. And that way we can do more of these presentations. And I think we already identified one that might be really useful to tenants in San Diego about rent increases.
And just as a reminder, this video will be uploaded onto the San Diego Law Library's YouTube page within the next week, if you want to refer anyone to come watch it. And it'll also be posted, or you can find it through our website as well. All right.
Great. Thank you.
Thank you so much for coming.